Josh, thanks for coming here today with us and spending your morning with us. Can you take a minute to introduce yourself? Tell us more about your organization and what does your day-to-day look like in your position?
Sure. So my name is Joshua Freezer. I work at Freezer Legal, which is a boutique law firm that I own and manage in Milwaukee, Wisconsin. And it's primarily a sports law practice. And I guess my day-to-day, any lawyer will tell you this, every day is different. But I can kind of put my practice into 4 different buckets. So first bucket, I work with athletes on everything from high school athletic association issues to all the way through to NIL disputes, licensing contracts, intellectual property, deal with the NCAA from time to time, deal with league offices from time to time, and everything in between. The second bucket, I do the back-end legal support for sports agencies. The third bucket, I work with sponsors in the sports space. And then the fourth bucket is I do outside general counsel work for sports industry businesses. So every day is a little bit different. I would say more often than not, I'm on the phone with clients, I'm meeting with clients, generally advising them on what they should be doing in terms of the legal perspective. But there's certainly a lot of hard legal work that's involved as well, reviewing contracts, drafting contracts, everything like that comes up as well.
Yeah. So you mentioned the industry, how did you term it?
Sports industry businesses?
Yeah. Okay. So tell me a little bit more about the sport industry businesses that you're, who would that be? You don't have to give client names, but like what services do they offer?
Sure. So I work with a soccer club that is mostly youth sports and high level, trying to remember the name. It's not equivalent to like AAU
Sure.
Type travel soccer, and they have a semi-pro team as well. So they do sponsorships, and they've got a kit with a logo, a sponsored logo on their jerseys. They've got sponsors around their stadium, small stadium obviously, but that's all present there. There's legal work that's needed, and then obviously they employ a lot of people. They've got a lot of athletes. They've got full-time coaches. So there's a ton of issues that come up, from intellectual property to contracts to labor and employment law. Everything is present there. So that's an example, sort of opposite end of the spectrum. Actually, a colleague of mine from Indiana owns a collectibles company, and I do outside counsel work for him. And it's mostly trading cards and things like that. But that's all sports industry stuff as well.
Yeah, that's really interesting. So for students that are thinking about, trying to figure out where they want to be in sports somehow, and they want to work in sport, but aren't really quite sure how to kind of navigate or trying to find their in. Can you explain your path of from college to obviously law school and to now? Like, can you just describe how you got from then to now and kind of give maybe a pathway for some students?
So I was a sport marketing and management major at Indiana University, really loved the program there. And I decided I wanted to sort of further specialize. And I think to me, being a sport marketing and management major, I was always terrified of working in ticket sales. That was one thing that I was like, I do not want to do that. And that's obviously a really common career path. Right after sport marketing and management, you go and you work in ticket sales. And I was like, I don't want to do that. So I was like, do I want to go get a master's? Do I want to go to law school? I wanted to specialize further in some way. And I kind of thought about some of the different opportunities out there. I really liked marketing, but I was like, you know what? I really like the legal field. And that was something that has always interested me. And I decided to go to law school. So I went to Marquette, which has a really good sports law program, and just continued on the path from there. During law school, I had the opportunity to work at the NCAA for the Office of the Committees on Infractions, which is essentially like the NCAA's trial court. And then from there, just sort of further specialize in the college athletic space, which has sort of led me to doing some work in the high school athletic space as well. And since then, I've owned a law firm, and it's every day is a little bit different. But a lot of the sports industry stuff comes through that.
Yeah. So when you're at the NCAA working in, you say like basically like trial court, what was your position? Like, what did you do in? I can only imagine you, Josh, like the law TV shows. Like I can only imagine.
Sure. So if you ever get the chance, they're all obviously not open to the public, but if you ever get the chance to see an NCAA infractions hearing, they are wildly fascinating, just because of the characters you get in the room. So the way that the NCAA infractions process works is you've got the enforcement staff, which is essentially like a DA's office, a U.S. attorney's office. They're the prosecutors. They go out, they investigate, they charge. We're alleging that these coaches have violated these rules, so on and so forth. And then you get to the Committee on Infractions. And when I was there, the Committee on Infractions had some incredibly impressive people on it. We had a former U.S. Attorney General. We had the commissioner of the SEC. And you can imagine you get those personalities in the same room and you test some legal theories out. It's not going to go according to plan. You're going to get some interesting questions. So I was essentially like a law clerk to that group, where a lot of what I was doing was reviewing and editing the decisions that they were publishing, critiquing, for grammar and format, making sure all the citations were correct. There is a sort of body of case law, so to speak, at the NCAA infractions world. This is public, this part of it. You can go on LSDBI, which is the database that the NCAA uses, and look at the different infractions cases. But yeah, wildly fascinating stuff. I mean, to be in the same room with some really high-profile coaches who are like, no, we didn't do that, and you get the, again, same folks, panel of members of the Committee on Infractions, former attorney generals, big law firm partners, some very impressive folks, university presidents, and they're like, no, we don't believe you. Can you explain that further? And some of them do get really hot and contested because you're talking about really, big sanctions. I mean, sometimes you're talking about postseason bans. You're talking about scholarship reductions. I mean, it's really big stuff. So yeah, wildly fascinating. I really enjoyed my time there.
I feel like that would be a great reality show.
Yes, if the NCAA had any interest in the public seeing what happened there, yes, no question about it.
Yeah, it'll probably never happen, but that would just be so interesting to...
Yeah, I think from the NCAA's perspective, they would never want anybody from the public seeing that, because you'd get fans calling in and you'd probably get death threats. And I mean, even we think about some really high-profile cases, like the North Carolina case from a handful of years ago, with the whole cheating scandal and academic impropriety. That was something that really got people, really ruffled some feathers, where members of the Committee on Infractions were, I think, personally getting threatened. And it's like, that is not something that we can have, I think, for clear and obvious reasons.
Yeah, sure. That's really interesting. On a side note, have you listened to the podcasts about the UNC?
I have not listened to podcasts about them, but certainly, I was at the NCAA very shortly after that, it was a couple years after that. And it was something that was sort of ever present, at least in our office, where, the Office of Committees on Infractions was always looking at it from the perspective of, well, how do we justify what we're doing here with what happened there? And I think that's a really important question, just in terms of fairness.
Yeah. So when we talk about youth sport, I think the legal side of it can get really lost, especially for students who don't know yet what the legal side of it even looks like. So what are, in your opinion, or in your experience, what are the most important things about the intersection of the law and youth sport?
Yeah, that's a great question. I think the most important thing to understand about the legal regulation of youth sport is that a lot of the context of youth sport takes place at school. And particularly when you're at a public school setting, it is completely different than when you're at a private school, when you're going and playing in a rec league that's not government owned and operated, because of the legal protections that you have. And it's, I think, a really interesting example way you could describe this is if you look at the NFL, for example. The NFL is a private employer, no government relation. If the NFL says, hey, we don't want you protesting during the national anthem, right? Which is a hot topic, right? It's something from some years ago, but it was a big issue. The NFL can do that. The NFL can say, hey, you're our employee. We don't want you doing that. But how about a high school, public high school? Now we're talking about the government censoring free speech. Obviously, student speech is viewed in a different lens than government censorship of speech in different contexts. But still, at the end of the day, we're talking about a state actor, a public institution, whether it's at the college level, at the high school level, saying, we don't want you to do that. And some really, really fascinating cases have come up in the free speech context, in the due process context, where somebody's kicked off a team. And I think that is the most important thing to understand about the youth sports legal regulation, particularly in schools. And if you look at like high school sports, this is really present where maybe 80% or so of schools in any given high school athletic association are going to be public schools. So they can regulate their student athletes differently than a private school could. And that is so important to the legal regulation of all of this, because if you have government intervention in some aspect, you've got all sorts of constitutional protections for the athletes that come with that. And I think the most important legal case for youth sports over the last handful of decades is the Brentwood case. And the Brentwood case went up to the US Supreme Court not once but twice, which is unheard of. But it was a high school athletics case in Tennessee where essentially the Supreme Court outlined a doctrine called the state action doctrine, and it's called what we call now the Brentwood test. And under that test, I would say in almost all contexts, high school athletic associations are going to be considered state actors. And if you have high school athletic associations saying, no, we're going to suspend you, no, you're not eligible because your family moved or whatever other reason it is, you've got all of these constitutional protections. You've got due process now. And having due process opens a whole can of worms, because the athletes that are participating, I mean, it's endless what protections they could have in the right context and the right circumstances. And I think the impact of that is paramount. I mean, it's really changed the landscape from the legal perspective of people having the ability to go in court and say, hey, high school athletic association, you violated my rights. Do they have a legit case? Sometimes yes, sometimes no. But the claims are there. There's more of a potential for it. And from the high school athletic association standpoint, it's something they need to be concerned with, because they can't arbitrarily do whatever they want with no recourse. If you look at, again, we'll go back to the NFL example, the owners in the NFL can say, we want to do this. This is what we're doing. They're a private employer. They're a private business. They can do that. But once you're talking about constitutional protections and government, it's completely different.
So the Brentwood case, so two questions. For those of us that are not in law, is not our specialty.
Sure.
Can you explain, number one, what due process is? And then number two, can you explain the Brentwood case a little bit more and what went into that and what came out of that?
Sure. So the Brentwood case was about football and football recruiting in the state of Tennessee. And so Brentwood was actually a private school, Brentwood Academy. I think it's in the Nashville area. But so the Tennessee Secondary, it's not High School Athletic Association, Tennessee Secondary Scholastic Athletic Association, whatever it is, they said, hey, Brentwood, we're going to suspend you. We're going to take some action against you, Brentwood, as a high school. And Brentwood,
but they're a private school.
They're a private school.
Okay.
But they said, we are going to take some corrective action against you for violating recruiting rules. And Brentwood Academy just so happened to have a very famous constitutional law professor who was a parent, who taught at Vanderbilt, who said, hey, this is a problem. They can't do that. And they said, Tennessee High School Athletic Association, you're a state actor. You have to afford us due process. You have to offer us the right of free speech. You have to give us all these protections that we would have. And the Tennessee High School Athletic Association said, no, wait, we've got this case law on the record that says, NCAA, you are not a state actor. Why? Because the NCAA has members from all 50 states, whereas everybody that's in the Tennessee High School Athletic Association are all members of one individual state. And that's how the Supreme Court distinguished that. And they said, no, that doesn't work in this context. It's different. So we are going to look at high school athletic associations. 80% of their members are public schools. A lot of their funding comes from public institutions. A lot of their control is government employees. In this instance, I think everybody on the board of control was all a government employee. And that was really important to the outcome of that case. And so the Supreme Court said, no, high school athletic associations, you're a state actor, and you have to afford due process to both individuals and to schools. And essentially what due process means is you're entitled to some fair proceeding. They can't act arbitrarily. If they're going to have rules, they have to follow them. You have to have an opportunity to be heard. You have to have a right to an appeal. Those are all things that we get in the due process context. We usually think about it in criminal law, where you have the right to a trial, you have the right to an appeal, you have a right to a jury, things like that, you have a right to an attorney. It's different in this context, but there's still some process that is owed to the constituents because it's the government that, again, we're saying it's state action. It's the government that's saying, no, you can't do that. No, you can't say that. No, we're going to prohibit you from doing this. So that, yeah, really, really important case there.
Yeah. So what was the result? And then how did it affect how other schools or youth sports are affected by that ruling?
Yeah, so at the beginning, it went back to the trial court and they said, yes, you are a state actor, Tennessee High School Athletic Association. And then they got to the question of free speech. And was this unregulated free speech censorship? And it went back up to the Supreme Court a second time, and the Supreme Court said, no, it's not. So that was the ultimate outcome there. Several years later, I'm sure every player on that team had long been gone. But the impact for us today is that you can bring claims against the High School Athletic Association and say, they didn't afford me due process. They're censoring my free speech. And every high school athletic association today, by and large, I mean, there's a couple that are split up between public and private schools, but even if your membership is 75 or 80% public schools, it's something you still have to worry about, where if somebody is saying, I want to appeal this, and you have no process for an appeal, that's a problem. If somebody is saying, I want to go out and I want to wear this armband protesting a war, right? When we all know that case, right, from Tinker many years ago protesting the Vietnam War. But what is the High School Athletic Association able to do there? Are they able to say, no, you can't do that? I mean, certainly in the sports context, you've got some latitude in terms of like regulating what you're able to wear in competition, but is it pure political speech? I mean, there's a lot of questions that come up, and I think high school athletic associations just have to navigate it a lot more carefully now.
Mm-hmm. So we know that concussions are getting a really big look at right now, from the NFL down, and that has affected participation rates in youth football. So the head injuries and any sort of injury really are really on the forefront of a lot of parents' minds, and how their kids are going to be affected by participating in youth sports. What on the legal side, what does injuries or head injuries, concussions, those sorts of things, what does that do for youth sport, and what are you seeing, or what do you know about how future youth sport managers need to kind of address those issues?
Yeah, so I think the biggest change that we've had in the last 15, 20 years or so is the passing of all of the Lystat laws. And this originally came from Washington, a football player named Zachary Lystat, who got a concussion, then got a second concussion, and obviously ended up being very, very injured.
Sorry to interrupt. What level? He was a college?
High school.
High school,
Yeah.
Okay.
And so ultimately what happened is these laws all went into effect. I think every single state, all 50 states, have some law that's similar to this. And essentially there's three requirements. So one is that they have to provide education to the coaches about looking for concussions, understanding concussion symptoms. The second piece of it is if there's a suspected concussion, or there's been some evidence of a concussion, the athlete has to be taken out of the game. It's required. They cannot go back into the game and participate again. And then the third prong of it is that they then need to be examined by a doctor and cleared to return. So whether that's a week after, 2 weeks after, a month after, they have to be cleared by a medical professional before they can go back into the game. And this is a requirement now. It's at the youth sport level, whether we're talking about middle school football, high school football, all across the board, it is a requirement. And it's a really big violation if you're not paying attention to that. Your coaches aren't trained properly, or you have a kid who doesn't get cleared medically to come back and return to the game, whether it's a week after or 2 weeks after, whatever it ends up being. So that is the biggest change that we've seen. I think there's a lot of positives that have come out of that. We're seeing an increase in reported concussions, which is good. I mean, it's not like there are actually more concussions, there's just more reported, which is good. And then the other thing we've seen a decrease in is the second concussions. And that, I think, the data out there tells us it's much more dangerous when you return and then you get the second concussion. The first one, it can be dangerous, but it's when you get the first one, you go back in right away, and then you get the second one. That's where the really bad damage usually gets done. And there's been some cut down on that because of the return to play rules.
Excellent. So a couple of questions about that strike me is those regulations, who do they apply to? Do they also apply to the rec league the neighborhood rec league football team, or is it just school sports that are, state actors?
Yeah, so it's every state law might be a little bit different. They're not exactly the same in language, but mostly they apply beyond just the scope of high school sports. Usually they do apply to rec sports and things like that too.
Okay. And what about what about the sports that aren't necessarily regulated by a high school association? So, for example, like cheerleading, oftentimes is not considered a sport under the high school association, um, sport association. So, what about those? Are there any, if a cheerleader would fall and get a concussion, for example, what are the legal ramifications of that athlete not going through that same process? Are there legal
Sure.
ramifications?
So, I mean, if you look at the perspective of when you might have legal claims, it's an athlete getting hurt. That's sort of an element that has to be present. And so, let's say you have an athlete that happens, they fall, they get the concussion, and they return to play, and they shouldn't have. There's a variety of legal claims that they could bring. So, one would be a violation of one of those laws that prevents exactly what we're talking about. And depending on the state, depending on the language, depending on the circumstances, they may have an argument. But then there's always pure negligence, right? Negligence is always on the table. It's something that's recognized in all 50 states. And they could very easily argue, you should have known that there was a concussion, absent any of these laws that protect youth athletes against going back into play when there's a concussion present. But yeah, absolutely, pure negligence. It's just, you saw they took a really big fall, they hit their head, they were dizzy and walking around and not looking like they were looking clearly concussed. You shouldn't have put them back in. I think the standard of care has increased, and the duty of care for coaches and any other officials that are involved, whether it's an organized sport at the high school level or something like cheerleading, yeah, you should know. I think the standard coach would know a concussion was present here, and there's something you should have done about that. I think that's pretty clear knowledge at this point.
Yeah, that brings up a really interesting question about coach training, right? Is it? I think about for example, cheer squads, because we're on this subject. There's a lot of coaches that are not trained, and they do not have training. And in the U.S., there is no required overall youth sport coach training that you have to do. It's not mandated by any means at the top level, at the national level. But talk to, thinking about future youth sport leaders, right? How can you prevent your organization, your school, your whatever context in which you have youth sport, how can you protect them from potential legal issues pertaining to coach negligence? How can you prevent that?
That's a great question. I mean, training is the most important thing, and we can talk about concussions. I think we can also talk about safe sport. And depending on the state that you're in, obviously the concussion laws differ a little bit, but safe sport's a national law. And in almost all contexts, I think high school coaches, cheerleading coaches that are not governed by a high school athletic association, they should still be aware and they should still be trained about that. And it may not be crystal clear about whether it's necessarily required, but I think for a risk mitigation standpoint, it's absolutely something that you should be doing. I think it's a really interesting quandary in youth sports where most of our coaches are volunteers, where they're not paid, they're just showing up. A lot of times it's just parents. But yeah, I mean, you absolutely should be doing those trainings and educating coaches about what to look for concussions. What do we need to be doing to make sure that there's no sexual abuse going on? It's stuff that you absolutely need to be making coaches aware of and holding coaches accountable to.
So for some of your clients, to prevent this sort of negligence or to prevent any sort of legal mishap, what are some of the things that, besides training, you could put in place, such as insurance or other risk management things that you would tell some of your clients?
Yeah, insurance is absolutely something that you absolutely have to have if you have youth sport participants in anything. But another thing I think is really paramount is liability waivers. And I think a lot of folks think that liability waivers are sort of a one-size-fits-all and it can be applied to anything. But liability waivers, it's actually every state views them a little bit differently. So we could have a liability waiver in a particular state, I'll say Wisconsin, where I practice law, and that liability waiver, it holds up in court. And the court says, yep, you got injured, you came and said, we want to sue you for negligence, but you signed a liability waiver, we're going to throw this case out. That same liability waiver might not hold up in a state like California, just because the analysis is going to be different about whether or not the liability waiver is permissible. And some states, a little more friendly, some states, a little less friendly in terms of liability waivers. So it's not a one-size-fits-all. You can't take one liability waiver and use it everywhere in the country. A client of mine that I work with, so he hosts NIL camps. So essentially what he does is he has college athletes come out and teach middle schoolers, high schoolers, whether it's football, basketball, soccer, anything like that. And one of the things that I said to him is we have to have liability waivers in addition to insurance, obviously. And the liability waivers, they've got to change. We're in California, it's got to be different than if we're in Georgia, because the state will view those liability waivers slightly differently depending on the particular doctrine in that state. And that's not a one-size-fits-all thing. It's even if you're doing the same event in Georgia or Florida, the liability waiver may have to change. And I think liability waivers can help. They're not a blanket. They're going to get you out of everything. But certainly ordinary negligence in some contexts, yes. But again, going back to my prior point, training coaches, making sure that you have as safe of an environment as you can, that's the best way forward. It's much easier for no one to get hurt than for someone to get hurt and you to say, well, actually, we've got this liability waiver, so you don't have any real legal claims. It's a lot easier for just no one to get hurt in the first place.
Right, right. So I'm thinking if every state is different, I'm thinking about the organizations that travel with their club. So whether it's club volleyball or soccer, and they sign, maybe they operate in, let's say, Kentucky, but they travel to Illinois for a tournament. If someone gets injured at the tournament, was what you are saying is it could be null and void based on this where they were playing? It
could, but usually when we're talking about liability, the ownership of liability belongs to the operator of the event. Okay. So in the context, and that's not to say that somebody couldn't get injured under the negligence of a coach that they're traveling with. It's certainly possible. But more likely than not, if they're traveling from one state to another state, they get injured in that other state, they're not going to be looking to their coaches or the organization, the travel team that they're traveling with for liability. They're going to be looking to the event organizer, whoever rented out the facility. Whoever organized the event that had 10 teams there. That is who the liability is going to be on. There may be a separate liability waiver that you've got to sign when you're participating at that location. But yes, that's usually how it would work, but it certainly is very fact specific.
Okay, so we have insurance, we have waivers. What else can we do to prevent any sort of legal issues that we may have, especially as it goes to coaches? We talked about training, but what else could we do?
Yeah, and another great thing to do is background checks. I think we're in a landscape where we're talking about sometimes very young children that are being left in the care of a coach. So background checks are really important. We want to make sure that any coaches don't have a criminal record, don't have anything concerning on there. That's a really important step to take. And then I think another thing that's sort of part of safe sport is having multiple coaches that are present at the same time. The mitigation of having two coaches versus one coach and something that could happen, the odds plummet when you have two adults in the room at the same time, where you have somebody who could say, hey, wait a second, we shouldn't be doing that, or that's not okay. Whereas if it's just one coach, particularly a one-on-one interaction between a coach and a youth sports participant, the opportunity is just so much more present than if you have multiple individuals who are trustworthy and all there at the same time, sort of checking each other.
And when you're looking at background checks, what do you want to make sure that your background check covers?
Yeah, I mean, the biggest thing is criminal record. I mean, obviously, there's other stuff that could come up on a background check, but any sort of criminal record, I would be very, very hesitant to let that coach, or be around children.
Mhm. All right, so let's move on to some of the ethical dilemmas that we may see in youth sport. There's always this balance of minors while also making sure eligibility is upheld. So, have you encountered any sort of specific example in your practice of where eligibility became a hot topic?
Eligibility is always a hot topic. I think one of the things that we see, particularly at the high school sports level, is always there are questions about, I want to transfer schools and I don't want to sit out. And depending on the state high school athletic association, there may be rules about that. Because obviously high school athletic associations are against students transferring schools just for sports. And that's an obvious reason. It makes sense. But there's certain carve-outs in most circumstances, and I can give you an example. In my state where I practice in Wisconsin, there's a rule that if your family makes a total and complete change in residence, you can be immediately eligible, and you don't have to sit out for a full year. So what does that look like? And there's so many ways that people have tried to get around that, right? You're going to live with your grandparents, or we're renting a house in a different school district. I mean, it really can create some interesting ethical issues. And I think from the high school athletic association perspective, it's okay. You're asking them to prove residence or prove that they actually moved. But what information are you asking for? I've seen high school athletic associations ask for tax returns, ask for bank statements, ask for all sorts of stuff that, okay, well, maybe we're getting into an interesting area of privacy protections that high school athletic association, again, I'll go back to the point I made earlier about we're probably talking about a state actor here. Can the government say to you, we need you to prove this in this way? And it really creates some interesting issues.
Yeah. Have you seen, what are some cases that you have personally worked on in terms of eligibility and making sure that everything is fair and just, and that the athletes still get the same opportunities?
Sure. So I've worked on a ton of eligibility cases, both at the NCAA level and then at the high school level, and a ton of stuff comes up all the time. And one interesting case that I worked on recently, I worked with an athlete from Ohio. And he was a very highly touted football player, the best football player in the state. And he wanted to participate in 7-on-7 competition, which is sort of an off-season, unsanctioned by the High School Athletic Association competition, sort of like an all-star type camp. And that was prohibited by the Ohio High School Athletic Association. And this particular athlete was suspended, and they told him, hey, if you keep participating in these, we're going to not let you participate. You're going to be suspended for the rest of the season if you keep doing this. And he said, wait, hold on a second. I'm kind of on the borderline of 4-star and 5-star, and I kind of want to be 5-star by all the services, and I want to move up the recruiting boards, because now that's really tied to the amount of NIL compensation that I can get at the next level. And previously, maybe stars in high school were a little speculative. It's you go to college or you're going to play at the next level. It's not guaranteed. But now it's somebody's offering you a certain dollar figure today. They're saying, we want to offer you this to come to our school now. But what if you can kind of move up those recruiting boards? And I think for this particular athlete, he said, I want to do that. I want to participate in these 7-on-7s. And is there a way that I can do that and still be eligible? I still want to play high school football for my senior year. And I worked with him on this and worked with the High School Athletic Association. And I said to them, I said, look, you're really suppressing the market value from the antitrust perspective. And we could talk about antitrust law. It's very technical and there's a lot to it. But long story short, high school athletic associations, much like the NCAA, shouldn't be restricting market competition without any sort of justifiable reason. And in this particular instance, it's, well, why can't they participate in 7-on-7s? And the reason was, well, we don't want them to. And it's, okay, well, why don't you want them to? And there's no justifiable reason for that. And in this exact instance, this particular client of mine, he was able to continue to participate in the 7-on-7s, moved up the boards, eventually was a 5-star recruit by all of the recruiting services, and now he plays at Oregon. And obviously, it helped him. And I think from that perspective, it was, okay, we need to get the High School Athletic Association to make him eligible, but at the end of the day, it's worth it. And it really made sense for him. And I think from the ethical perspective, we talk about NIL as I think a lot of people view it as something that's bad. But I think from the athlete's perspective, it's life-changing amounts of money potentially. And if you have an opportunity to engage in that or increase that, why wouldn't you?
You brought up some great points that I want to ask you about. The first one is recruiting boards and the rankings. Do you ever see any sort of number one, where did the rankings come from best of your knowledge? But then also, are there any legal ramifications of those rankings? Of could there be some lawsuit about where I'm ranked or how I was ranked or
Sure. So, I mean, by and large, they're independent media companies, for lack of a better way of describing them, that go out. They'll have scouts who, are talent evaluators who say, yeah, this guy's really good, and I think he's better than that guy. And if you piece it all together on a national scale, at a state scale, you can say, we think this particular athlete is the best center in Indiana or any state you could think of. And so I don't know that you'd have any legal claims for not getting what you want. I mean, it is sort of protected by the First Amendment. It's free speech. It's just media reporting, same as the news. Just because the news isn't favorable doesn't mean that you've got any legal claims there, even though obviously you would want it to be very favorable in this instance.
so if they what if they proved that coaches were relying on that measurement for their opportunities for NIL or for scholarship even? Could they have a case there?
No, I don't think so. I think coaches do rely on those big boards, certainly. I think they've got their own independent talent evaluators. But no question about it, if you have somebody that's a 5-star recruit rated by all of the services, some coaches are going to say, yeah, we'd be willing to take that guy, even though we don't think he's all that. But without any concerted action, you're not going to really have those antitrust claims. I think what's interesting when we talk about the NCAA or we talk about high school athletic associations suppressing value there, it's concerted action, which is a requirement of antitrust laws. You get a large group of people that can influence a market as a group that have said, we're going to suppress this. But one individual coach, no, because some other coach could say, we're willing to pay you more.
Okay. And so NIL in the college athletics is huge and it's changing the game on so many levels. Our focus, of course, is youth sports, but there is definitely a trickle-down effect. What NIL in college down to high school students, high school athletes specifically, what are you seeing the trickle-down effect being? You gave one example that his NIL money could go up if he wasn't prevented from playing in these 7-on-7s. What else are you seeing that NIL is affecting?
Yeah, it's unquestionably it's present and it's there. I think we're at the point where I want to say off the top of my head, 38 states allow it at the high school level entirely. So if you're a high school athlete in California, you can engage in NIL now. You can go out and you can make money on social media. And we look at some really high-profile athletes, particularly coming from California, Bronny James. I know he's a little bit of a different circumstance, but it's certainly there. We look at Juju Watkins. I mean, Juju Watkins made a ton of money on NIL while she was still in high school. And that is absolutely present there where you're talking about maybe a 15-year-old, a 16-year-old making hundreds of thousands of dollars. But like it or not, it's here. So that's one piece of it. And then the other piece of it is obviously the recruiting perspective, where if you're a senior in high school, you're a junior in high school, and you're looking to play at the collegiate level, you're highly recruited, there's going to be NIL offers on the table. No question about it.
And I just think, as a parent, my 15, 16, 17-year-old getting these huge offers for NIL, for their work right now, and not even for college. What are some of the implications of labor laws for these students that are getting paid? Or is it so new that we don't yet know how we're going to regulate and make sure these students aren't getting taken advantage of? Or is there something already in place that you're aware of?
Yeah, so one of the interesting quandaries of NIL is it's actually not labor per se, because they're independent contractors. They're not working, punching a clock and working a certain number of hours. So labor laws, by and large, don't apply, which is true at the collegiate level and true at the high school level. But I think, if you look at what regulations are there, I think, unfortunately, we haven't seen it yet. I think it's somewhere down the line we're going to see some really bad stories about potentially parents taking advantage, parents stealing money, outside actors, maybe agents that are taking money where they shouldn't be. And people are going to say, hold on a second, we need to protect our high school student athletes and our collegiate student athletes that are coming into, in some instances, millions of dollars, hundreds of thousands of dollars, where we want to regulate this. And I really draw this to what I think of immediately is the child actor laws, where if you think about child actors and entertainers, it's a different context because it is labor for them. But a certain amount of money has to go into a trust fund. Their parents can't take it. And obviously that was reactionary as well, where way back when you had an actor whose parents stole all of his money. And then we said, okay, we're going to regulate this. We need to protect these child entertainers. And that's something that I could see down the line here. I think when we talk about athletes, it's no different from child influencers who can make a ton of money reviewing toys on YouTube. And do the parents take all of that? I think it's a really interesting question. But certainly, athletes need to be protected in that sense and understand what money is theirs. How is it coming in? Is it a business? Is it an LLC? I mean, I think there's a lot of legal implications there.
Yeah. Gosh, that's so interesting to think about, because then you start to say, well, it's not labor necessarily, but they still have to post on social media. So in a way, that is labor because they have to, keep up their social media image and.
Right. It is certainly work, but in the legal context, when we're talking about labor, they have to meet the test for employee. And in this instance, they're not an employee. They're paid as a 1099 independent contractor, so they don't get the protection of labor law, which is really interesting. But yes, no question about it. I mean, we've seen this maybe more in the influencer space than the athlete space, where you hear about parents that are essentially taking advantage of their 12-year-old kids that they're having, working a job, going out on social media and posting and keeping up an image and doing all of this stuff just so that they can generate some more money for their family.
Gosh, that's so interesting and so scary.
And scary.
Scary. Okay, so what else? NIL, trickle down. Students and young athletes have the opportunity now to make money and get into contracts with companies and organizations that want to pay them for their NIL. What else does that mean for, legally speaking, what else does that mean for the child?
It means a lot. So contracts can work a lot of different ways. You can have long-term contracts, you can have short-term contracts. I think one really important factor here is that most high school athletes are under the age of 18. And not every state, the age of majority is 18, maybe 47 or so of them. But if you're under 18 in most circumstances, you can't legally sign a contract. A parent has to sign it on your behalf. But what does that contract look like? Is it a 10-year deal? Is it an irrevocable license? I know we really use big, scary legal words out there, but the implications can be really important. And the example that I always give folks is, let's say you're a senior in high school, you're a freshman in college, somebody wants to give you $100 in exchange for some NIL deal. Sure, $100, that sounds great. That sounds like a lot of money. Well, what happens in a couple years when you're a first-round pick and they say, oh wait, you gave us all of these rights when you were in high school, when you were a freshman in college, and you agreed that you're going to give us everything in perpetuity, and we paid you our $100, and that's it. We don't owe you anything else. That's really scary. I mean, you've got to know what you're agreeing to and what you're giving up as a high school athlete.
Which is scary because it's probably the first time they or their parents have ever dealt with anything like this, and therefore they wouldn't know what to do. Is that or what to look out for maybe, is that maybe a argument for having something like an agent?
Yeah, I think having an agent is a really interesting question. I think whether it's necessary is sort of a personal decision on how much it's going to help you and what the prospects are. I personally think it probably would help, particularly for athletes at a higher profile level. But you've got to be careful there too, because you can sign a contract with an agent that can be just as problematic, if not more problematic, than a contract you sign with a brand. No question about it, it can help. But my recommendation, easy to say from my chair, but work with a lawyer. If you're signing any kind of contract, it really easy to say from my chair as an attorney, but it certainly is important, especially if you're agreeing to any kind of long-term licensing agreement.
Yeah. So we've hit on a number of different NIL kind of trickle down effects, but we've mainly talked about high school athletes at this point. What about other contexts of youth sports, such as like sport academies, like an IMG? How do you see NIL maybe having a trickle down effect in that space?
Yeah, no question about it. I think we've seen a commercialization of sport across the board, where we're talking about even just regular old high school sports are on ESPN now. I mean, we'll see an IMG Academy that plays on national TV. It's not uncommon. So I think with NIL, that's only going to continue to grow. I mean, just the opportunities there. And I think the ROI, so to speak, if you're a family of a high school athlete, it's so clear and apparent now in the NIL era, where previously we were saying we're going to pay for IMG Academy, it's an investment, but hopefully down the line we'll recoup that because you're going to get to the NFL, you're going to get to the NBA, you're going to become a professional tennis player. Whereas now with NIL, we can really see the ROI pretty quickly, where if we're going to spend, let's call it $100,000 to go to IMG Academy or a similar type of sports academy for high school, and then we're getting that $100,000 right back and then some once they get to the collegiate level, because they've rocketed up those recruiting big boards, they've gotten more exposure. Yeah, no question about it. I think there's only going to be more folks that want to commercialize that aspect of sport, because again, the return on investment when we're talking about you get to the collegiate level, if you're high profile enough, you are going to make money now. Yeah, that's only going to continue.
Which is so interesting, because then it goes back to the families that can put forth that money in the beginning and, up front, versus those that maybe don't have the funds right now to do that. And then it becomes this potentially big problem of, trying to figure out how to pay for that, and NIL at a younger age. And I mean, I just see so many dominoes falling here.
Yeah, unfortunately, I think that's an issue that has always been present in youth sport, and I don't know what the answer is to it. It's not new. Maybe it's even more exacerbated now, but it certainly is not new that families that come from means have more access to better trainers, better coaches, better opportunities. I mean, unfortunately, that's just always been present, and it doesn't feel fair, but I just don't know what the right answer is to solve that problem. And yes, you're spot on. I think it only will become even more present, even more exacerbated as things like IMG Academy, Montverde Academy just become more and more present for really elite athletes.
Mm-hmm. Which goes to our book, right? Our book is all about the business side of youth sport, what it is, what it has been, and where it could be going. Whether it's right or not, this is the future of youth sport. It is a business, and it will continue to move that way as long as we govern it like we do, right?
Yeah, and we look at youth sport, and I think it's viewed in a different context than we look at professional sport. But if you look at across the board, and I'm sure you've got the statistics on this, not me, not my area of expertise, but youth sports is a bigger business than college sports, bigger business than professional sports, just because of the levels of participation. We're not talking about 500 NBA players. We're talking about millions and millions of people, and they all need equipment. They all need helmets. They all have fields that they've got to practice on. The business of youth sport is huge. And I think from the legal perspective, maybe the big picture implications might be a little bit less, because we're not talking about an individual athlete making millions of dollars, although maybe now we are with NIL. But yes, no question about it, the business side of it is absolutely there. I think as that only grows and continues to evolve, there's only more of a need for lawyers, there's more legal regulation in the space.
Yeah, so good idea for students that are thinking maybe they want to go into sport, but they want to be a lawyer too, so maybe that's a great opportunity that they can see.
Yeah, I mean, I always think that being a lawyer is a great career path. Personally, I enjoy it.
Personally speaking.
I wouldn't advise anyone not to go to law school. I think if it's something you're passionate about, it's a great path forward. And I think there's so many things that you can do with a law degree in the sports context that maybe you aren't actually doing the real hardcore legal work, but it's still important. I mean, if you look at the NCAA, a very large percentage of folks who work at the NCAA national office, they're lawyers, but they're kind of doing a quasi, legal type work. Same thing is true at high school athletic associations. Same is true for high school athletic directors. If you've got a law degree, that probably helps. If you look at college, a lot of athletic directors have a law degree, even though they're practicing, quasi NCAA rule book, which is not law. But yeah, absolutely, it helps, and those career paths are there. You don't have to be sitting in a courtroom arguing before a judge to use your legal skills in the sports context.
Yeah, that's great. That's great information. Okay, Josh, so grateful that you have been here with us to just share your experience and your expertise with us and the students that will get to enjoy this textbook and our interviews. But I want to finish with a few rapid fire questions. So
Sure.
Are you ready for this? Okay. What is your most memorable moment in your career so far?
That's a great question. I'm going to have to completely lean away from youth sports, unfortunately.
Yeah, that's okay.
But one of the cooler clients I had the opportunity to work with was actually one of the league MVPs. I won't tell you who it is, that we've got in Milwaukee. So working with him was a really incredible opportunity, and really sort of a milestone in my legal career to work with one of the most marketable and high-profile athletes on the planet.
That's very cool. What do you consider your greatest success of your career?
Sure. So I think as a lawyer, and I'm not a trial lawyer, I don't do trials, I don't do litigation. So I think when we're talking about contracts, we're talking about corporate counseling, we're talking about advising athletes, it generally isn't a win or lose. It's okay, we all came in the middle and we're all happy. Whereas trial litigation, you've got to win and lose. But I actually had one circumstance, and this is going back to youth sports, that I did have to go into court and litigate against the Wisconsin High School Athletic Association. And it was a context where what I thought they were doing was so egregious that I was like, you know what? We actually have to go into court and resolve this issue. And about a week after we filed the lawsuit, they came up with another reason that they could make this particular student eligible, and that was the end of that. But that felt like an actual victory for me, because it wasn't like, oh, we all signed a contract, we're all happy. It was, no, we went into court and we got what we wanted, and we won. That felt like a really big victory for me.
That's so cool. I can just imagine you in a court. I just want to see you, Josh, in a courtroom, like.
Fortunately, we just filed the stuff. I didn't actually have to go into the court and argue. We didn't even get to that point, but we got what we wanted, which is what we were obviously going for.
That's what matters. Okay, what has been a great failure in your career and what was the lesson you learned from it?
I don't know that I've got any one particular great failure that stands out for me, but I think I've got a lot of small failures. And I think anybody in building a career, whether it's in the sports space or doing anything else, you've got to learn from your mistakes. And you've got to be willing to try stuff, and it doesn't work, it doesn't work. You've got to be able to pivot, you've got to be able to try something a little bit differently, or just scrap it entirely and say, this isn't working. And I think there's so many things, so many examples I could give you of things that I'm like, this is a great idea. And then 2 months in, I'm like, yep, this isn't working. We've got to scrap this is no good. But I think being willing to learn, willing to try new things, that's how you build your career.
Yeah, I think that's so important for students to hear is, we can bring in industry experts like yourself or people that have a lot of experience. And sometimes for students, it can look like, oh, they got it all together. Like they knew exactly what to do when they were my age, like they've always been successful. But I think it's important for students of all ages to recognize that failure is very common, and any person that has had success has also had failure. So it's great to hear that, like, it's not been all perfect in your career.
I mean, I think about the most successful people I know. Every single one of them probably started 2 or 3 businesses that failed before they found the one that really worked. I mean, no question about it. You've got to try different things. You've got to explore different opportunities and take it as a learning experience for anything going forward.
Yeah, great. Okay, if you could give a future youth sport professional one piece of advice to think about the students that are listening here, what would it be?
That is a really loaded question. I think there's so many things that you could do. I mean, again, I'll sort of tie this into the legal perspective. If you don't go to law school, maybe take that legal and sport class that you've got at your school and try and pay attention as best as you can. I think having some baseline understanding of legal regulation can really help. And I always say, from my perspective, the best thing that I can do as a lawyer is understand what the clients are going through. And the best thing that the clients can do is understand what I'm going through. And if we're kind of in the middle, it makes my job a lot easier, and it'll make their job a lot easier. Where if they've got some base level understanding of, again, we talked about all of these legal concepts, but some baseline understanding, I think that can really be beneficial.
Okay, great. What's one misconception of your industry, let's go specifically with the legal industry, sport legal industry, that you would want corrected?
I think the biggest misconception out there right now is in NIL. And I know we talked about NIL again. I said we could talk about NIL for hours. But I think NIL is really confusing to folks, whether we're talking about brand deals or we're talking about collective deals. We're talking about potentially revenue sharing that's probably coming next year at the collegiate level. And I think there's so much confusion about what the rules are, who is paying, where the money's coming from, how athletes are getting compensated, what that compensation is structured as. I think there are so many misconceptions out there about that.
Oh. So is there one in particular that you're like, I wish everybody knew this? Is there one in particular?
Sure. I think if we look at the last 4 years or so, everything that we have seen when we say Michigan has offered this particular athlete X number of dollars in NIL, that is largely coming from a collective. In the future is probably going to be coming from the university itself that has offered that. And that's sort of a licensing contract, which is completely different from Gatorade showing up and saying, hey, we want to have some ad space on your Instagram feed, which is just completely different from those two things. And I think when we hear NIL, name, image, and likeness, we think it's sponsorship and endorsement. But I think the waters have been a little bit muddied by the whole collective NIL business, which is different, again, from true sponsorship and endorsement. Nike, Adidas, Gatorade showing up and saying, hey, we want to sponsor you.
And do you see that trickling down to the high school space?
I sure do. Yeah, I think a lot of the contracts that I see, both on the collective side and then also, the endorsements, that all trickles down to high school. I mean, if you think about when recruiting happens, it's at the high school level by and large, particularly for those collective deals. So yeah, no question it's there. And I've even heard of a handful of high school collectives starting. Again, going back to youth sport, back to high school sport, I think a lot of money has started to flow into like AAU. And, I've heard about folks thinking about starting collectives for like EYBL teams and stuff like that. And that's all present. I mean, that's trickling down and it's only going to continue.
Oh man, so that could potentially mean that high schools could now get funding for specifically NIL type of things.
It could happen. Yeah, I think a lot of the state high school athletic associations have said, no, we're opposed to that. But does it happen eventually?
Oh.
It wouldn't be surprised. And then, going back to, we'll tie this full circle to that Brentwood case.
Yeah.
What happens if a school says, hey, high school athletic association, state actor, you're regulating how we're doing this? I don't know, right? Some really interesting legal questions there.
It's going to be the wild, wild west there for a few years until it all kind of gets taken care of. How has your personal experience in youth sport informed the work that you do?
That is a great question. So I loved my time in youth sports. Absolutely loved it. Played basketball and football growing up. And I think one of the things that I did, I guess this is sort of an interesting take on it, but when I was in 8th grade, going into 9th grade, I decided that I didn't want to play basketball in high school because I wanted to coach basketball. And I coached rec middle school basketball, took up a ton of my time, eventually kind of worked my way up, worked with an AAU program when I was in high school, and then I worked with the middle school travel team when I was in high school as well as an assistant coach. And I absolutely loved that experience. I mean, to me, both seeing the coaching side of it, the participant side of it, I absolutely understand the challenges and unique pieces that come with that. And I think for me as a professional, obviously I'm not going out and coaching basketball anymore. But I think having the understanding of the structure and what the players are going through, no question about it, I think that really has guided me. And I would like to think maybe helps me connect with clients a little bit more.
Mm-hmm. Yeah, for sure. I would definitely think so.
Yeah.
I definitely think so. All right, last question. Ready for it?
Sure.
Favorite coach of all time?
Favorite coach that I have worked with, that I just watched on TV?
Take it. Yeah.
Oh, that is a really good question. All right, so I'm going to have to go back to youth sport example. When I was in middle school, my middle school football coach, Coach Tracy Gamble, it was just an unbelievable person. And I think that was my first exposure to a coach that really cared about us as individuals beyond just us as athletes. And I mean, he was the type of coach where he was checking report cards, and if you weren't doing well in school, he was making sure you were getting extra help. And he took the time to make sure that he got to know our parents, and just probably one of the nicest people I've ever met in my life. And he was a great football coach. We had success, won a middle school championship. But I mean, for him, it was about bringing us together, making people friends on the team that wouldn't have otherwise been friends. And just he had such a care for us as individuals, and it wasn't all about football. And I think the best coaches are like that, in my perspective. It's, you're showing up, you're there to get better at your sport, but do they care about you off the court, off the field? Those are the coaches that I think really stick with you for life, and this particular coach sticks with me for life. And I stay in touch with him because he's such a great guy. Yeah.
I was just going to ask, do you still talk with him? Do you still?
Yeah, on occasion. I still talk to him, Facebook and all that.
Yeah.
But, yeah.
That's cool. That's cool. You know what I think is like the coolest thing about this question is that no one answers it with the NBA coach that they love.
Mm-hmm.
It's always the one that made a big impact on their life, and which comes back to why most people do youth sport, is they really want to have a positive impact on the students they work with or they get to serve in some capacity.
Right, absolutely, no question about it. And I think to sort of tie that in with what I did as a coach, hopefully I had an impact on my players. I know they all really liked me at that point when I was in high school, but I even think about some of the athletes I've had the opportunity to work with as a lawyer. I mean, I've had parents crying on the phone with joy because I was able to help them get through the eligibility process. And I mean, people that it's I don't want to say it's life-changing to them, but to say we were not expecting our kid to be able to play high school sports anymore, and you were able to help us, and now he's eligible. And that, I mean, it means a ton to people. I mean, it's like you see anybody that plays high school sports or middle school sports, it means a lot to people. Parents show up to every game, every practice, they're watching. I mean, it's just such a big investment of your life, and to be able to have an impact on an individual where they've gone out and they still get their senior season. I mean, it's a handful of times that I've seen it, and it's like every parent, they're just so appreciative and so thankful. And to me, I look at that in the same context where it's, in the same sense as a coach, it's really impactful because you get the opportunity to play, and you get the opportunity to get back on the court and really enjoy what you're doing and what you work so hard for.
That's awesome. That's awesome. Well, thank you so much for your time today and for your investment in the students that we get to serve. But thanks for sharing your expertise.
Thanks so much, Hope.
Thanks.